Hey everybody, good morning, and glad you're here on this wonderful Friday morning here in summer 2020. My name is JD Houvener, and you're in the right spot if you're an inventor, entrepreneur, business owner that's curious about patents. And maybe you've got a few questions in mind that you want to bring up, and I'd be happy to answer them if I'm able to. As you can see down below, I am JD Houvener, and I've added the titles this week. ESQ, which is short for Esquire, MBA. I've got a Master's in Business Administration as well as a professional engineer's license. So yeah, a lot of credentials, but you know what? I'm just a guy, a patent attorney, having fun here on Friday mornings with you guys. So happy to answer any questions you've got. That'll be prioritized. If you want to have any feedback with me, I will take live questions first. I do have actually 7 questions I'm going to be going into from the avo.com dashboard. So if you're new to this, awesome. Give us a like, share this with your friends on social. I want to have this be a thriving community of folks out there that have got, real inventions that want to change the world. This year it's been incredible, right? I mean, a lot of change, obviously, with COVID. A lot of people are at home, and we've been blessed with this opportunity to serve inventors that have now a little more free time, right? They're not able to get out as much and do the community and in-person activities that they normally do. They're at home and they want to invent, they want to create, they want to have these side businesses or entrepreneur ventures, and they're able to do that now more than ever. So we've been really getting a lot of impact, a lot of results for inventors with solutions, specifically to masks or personal protective equipment. Ways to handle transactions at a distance, or relay mail, or do things that we normally did in 2019, but now have to have new ways to do that. So that's more hygienic, more creative. And anyway, it's been really unique and a fun opportunity for us to handle those. So if you have questions about your invention, please hold off from sharing the exact details of what your invention is. This is not the place to do that. Okay, big disclaimer. I do want to be able to help answer any general questions you have about the patent process. Everything from when you're at the idea stage, should you bring another partner on, investors, how do you do patent searching, what goes into that, what does it mean when you get it filed, how do you know when you're patent pending, how long does it take? I mean, all those questions, anything goes, all right? And it's sort of a nice place to start. And I always like to kind of welcome first-time viewers. If you're brand new to this and you want just a single piece, a single resource to go to, I'm going to point you to my book, Bold Ideas, The Inventor's Guide to Patents. This book has got it all the major nuggets, the top 50 questions and answers that I've received from inventors over the years. This is available for free. I'm giving it to you, no questions asked. We'll give it to you a free PDF download on our website today. If you go to boldip.com and fill out a quick little form, and we'll let you get into it, let you read into it, get educated. I'm a big proponent of inventors knowing what they're getting into. We're law firms, we're lawyers. We're not necessarily, here to take your money immediately. Okay, we want to make sure you're in a good position. You've educated yourself, you've brought your invention forward, and you've got a really good plan to bring this invention to market. That's when we want to help you, usher you forward. So when you're ready, we will be here. And so that's why I'm doing a program like this to, maybe get people off that hump where they're sort of not really ready if they want to move forward or not. They've had this idea spinning in their head. So that's what this is about. It's helping you kind of, shoot a question out. There's no question too simple. Nothing that's, going to shock me. I've answered a lot of questions over the years. So I've heard it all. Okay. And again, just please do not share any confidential information. We will not have that reserved for a legal consultation where we would have that attorney-client privilege. Okay, so no live questions yet, and I do know we're at a minute delayed on the live broadcast. So if you've asked a question, just give it a minute or two, and I will hopefully see that pop up on this platform, and we'll get to that. Okay, so I did post a link up above. Hopefully you can see that to get a copy of the book. Okay, there's a link right there. And then also, if you're ready to schedule a consultation, we do have some really good folks that I've trained to help onboard and make sure that patents is really the right fit for you. And once they've sort of screened you and qualified you, then they will be able to schedule you with a patent attorney. We've called them advisors, and I've trained them myself, and they're excellent at identifying the right area of law. Hey, maybe you're looking at business law, or you maybe need to take care of a few things first before patents, before you're ready to talk with the patent attorney. they will help you kind of appreciate that, then the timing. All right, so I'm going to go ahead and share screen here. I'm going to let you guys take a look at the avlo.com dashboard. And here we go. Let's share screen one. And so Avlo's been a great platform for me to be able to volunteer my time over the years. As you can see, I've sent in 184 answers to anonymous question askers from around the country, mostly about patent law, but definitely doing trademark as well. We received 25 endorsements and got a lot of stars here as well. So it's a great place to come if you want to get some help, just get started toward getting an answer. So let's jump in on the trademark side. I've got 4 open questions that we're going to go through today. The first one here looks like it's about registering a trademark. And just so you guys know, I'm reading these live. I haven't prepped answers before. So some of these may be a little out there. Okay, first one is coming from Irvine, California. Can I register a trademark, e.g. the ship LGBT, if someone already registered the ship? So they want to try to get this more descriptive term. So they also say the service of both trademarks is identical. Well, that may be problematic. And this last sentence here actually really gets to the heart of the concern with trademarks, is that we don't want to have customers be confused, okay? And so if there is a problem, if it's the same type of industry, let's just say it's, I don't know, a theater, okay? It's a theater and it's shaped like the ship, right? Like an actual pirate ship or something. And you sit inside the ship and you watch the movie. If that company's already up and running, right, and they're showing movies and they're collecting money from customers that want to buy and watch a movie on a pirate ship, and it's called The Ship, okay, and you want to start a competing company called The Ship LGBT, and maybe you want to, really be, promoting and advocating for the LGBT rights, and maybe you've got a rainbow banner, maybe you've got additional thematic aspects of your business that you want to really push. I think it's still going to be quite difficult. Okay, I'm not saying it's impossible, but quite difficult to try to protect that one distinction of adding LGBT if you're going to still use the term the ship. And if you're going to be offering the same type of service, movie theaters, and even if you're having them on a different type of platform, if it's the same type of area of commerce, customers could be confused, right? People that are used to going to the ship, they now see the ship LGBT and they think that they're the same company. And so that type of confusion would likely lead to a rejection from the trademark office, okay? Let's go to the next question here. I'll always check back and see if you have any live questions. Okay, I don't see any right there. Okay, so the second one is coming out of Palm Desert, California. And this one is looking for advice on trademark on my business name. So they lost their job and they've had their company name and domain for many years. I don't want anyone in different industries to use my brand name. However, because the brand name can be used in different goods and services, I just want to get the right advice before filling out the USPTO trademark forms. The name is available through searching. Thank you for your time and consideration. Okay, well, I mean, the thrust of the issue here is you're going to have to select areas of commerce, right? You got to understand and provide your attorney information. Okay, well, how are you doing business now, or what are your plans for doing business in the future? It's really not possible for a company, for an ongoing business, to do it all, right? To be everything from doing insurance to practicing law to being a carnival host to selling binoculars online. I mean, you can't do it all. So there will be an issue with having to select a specific classification, is what it's called. And what that means is that once you get through prosecution and you get your registered trademark, any areas of classification that you did not select will be available, okay, in theory, for someone else to use. That's true for almost all marks. Now, there are very few marks that have sort of risen to the level of famous, right? Think of Nike, McDonald's, Starbucks. those are brands that are so well known that they do actually have some sort of an umbrella rights on ancillary or even somewhat related classifications, even though they don't actually have registration in them. If I want to start up a restaurant, Starbucks hamburgers, that's still going to be a conflict because people will still recognize that name Starbucks and think that it's the same brand. Okay, hope that helps a little bit. Okay, and we'll just cruise through the third of fourth questions on trademark. I apologize, I'm a little bit throat here. Okay, so out of San Francisco, this question is about a web domain purchase. So they're planning on starting a new business, and they picked a very descriptive name. The business and trademark for this name is available for registration, so they think. And so I'm planning to do both of the registrations to start with. My related question is about corresponding to the name and domain names. There's a domain name with the exact word available that I can potentially work with, but it's got a premium domain. Assuming I get both, the business name and the trademark name is officially registered. Do I have any rights for the .com usage? My one thought is that after name registrations are complete, I should be able to protect the name, but not allow anyone to compete or operate the website. This is true, okay? This is true. There's a lot of things going on here, but at the high level, trademark law will trump a domain ownership, okay? So if you're able to get a registration for that specific name in the industry, and that domain name and that website, right, is actually up and in the same classification, as long as you have prior rights, that's the key, okay? And assuming that whoever has the domain name, you've been using the name longer than they have for the same classification, then you will have the ability to prevent them from using that name in commerce, which would include e-commerce if they're indeed selling. But I wonder whether that premium domain, that domain that you want, if they've actually been selling in the same classification as you have longer. That might be something to really consider before you go to apply for registration, that maybe they may be able to prevent you from getting a mark in the first place. So have a look at that. I think we should talk in more specifics about what you have so I can give you more guidance. All right, good question though. Hey, Alan, good to see you. Thanks for hopping on, appreciate you. Let me know if you have any questions, okay? Appreciate you saying hi. Okay, cool. Let's go to this fourth question here. This is still a trademark application question. This one's out of Orlando, Florida. Okay, so can I register for a trademark on a brand name? I own a clothing brand, and recently there's arisen a clothing brand of the same name. I currently do not have a trademark on the brand name, and neither does the other brand. So if I would register for a mark on this name, would I be able to put an end to the other brand using the same name? And how long can it take until I can do that? Well, it all comes down to who started using the mark first. That is pure and simple. And beyond that, interstate, meaning selling from one state to another, really is one of the biggest ways to start showing that you're using the name at the federal level. So it could be that they're just a local brand and they've only sold in a very small geographic area. You may be able to get rights still, even if you're the second one to use that name in a different region. And you're able to show that you get federal registration, you'd get everything but that little region where they have been selling for all those years. So all of it comes down to timing and whether you came first on that mark. Okay, well, I won't jump to the patent questions here unless I have any live questions for our main audience here. All right, sounds good. Nothing yet. So let's do these three. So out of Alexandria, Virginia, which is funny enough, that's where the headquarters of the United States Patent and Trademark Office is, in Alexandria, Virginia. So this is the first final rejection from the USPTO. What actions are at our disposal? We received a final rejection from the USPTO after 3 other patent applications were issued after 1 non-final action for each. This is the first time we received a final rejection, and this is a new scenario. What actions may we take? Thank you in advance. Well, you're welcome. I mean, hey, it's really going to depend on what they rejected. The most legal answer I can say, yeah, right, it depends. So final rejection, it isn't something you should be like, oh my gosh, we're rejected, it's all over. Absolutely not. I mean, it's pretty common to get a final rejection. And in my little novel, that means you've been fighting. You've been really doing your best to negotiate and push for the inventor's rights. Typically, the way to go is you submit your application, right? The examiner reviews it. They give a non-final office action, and you come back with legal arguments, amendments, and such. And usually the next response is a final. So it's usually just a second rejection. What happens next is, depending on how severe, right, how dire the rejection is, you can make a decision. Say, look, I think we have plenty of room to argue here. I think the examiner just isn't thinking about it the same way as us. Let's do a examiner interview, right, and just go talk with them. And him or her, they'll explain what their scenario is, what they're seeing from their end. The inventor and especially the attorney will argue and explain what's going on, where they're coming from, and usually there's a place where they can meet. And you'll come up with a way to file a request for continued examination, RCE. And that will just start the process over again, where you'll be guaranteed at least a non-final office action again, and then potentially another final. But we've done 2 or 3 RCEs before, and it is a little bit expensive. There are some fees involved, but you just got to make sure that when you move forward, that there's really a feasible way, that there really is a way around the examiner's rejection. So every single one of them, of course, is unique, and we'd have to take a look at what the notice says to know how complicated the response is going to be. So love to help you with that. Please follow up with me if you'd like to set up a consultation. Okay, cool. So number 2 is out of Las Vegas, Nevada. Do I need an electronic schematics to file a utility patent? What kind of device that integrates with the car alarm to file a utility patent do I need to include? Here we go. Electronic diagrams. Well, I would say yes, typically yes, especially if you are going to be claiming that electrical circuit. Right? If what you believe is new is within that circuit, then definitely you should be explaining that through the specification and through diagrams. If you're using sort of a off-the-shelf electronic circuit or component, and you're not adding anything new to it, you can just say a capacitor of this size, or an electronic transmitter, or whatever the actual device is part of the system that you've invented. So, like I said, if you're creating a new circuit, if anything has been tweaked or added or modified from what's sort of on the reference or the prior art, then you should include that. Okay, hope that helps there. Okay, last question here from Avo is out of Chicago, Illinois, about how specific they should be about describing an invention in the provisional. So writing a patent, they are, and wondering if I will need to have specific measurements at the provisional patent stage, or if I can stay broad and only add specific measurements in the final patent. Well, there you go. No, you should not include specific measurements and dimensions, for example, really at any point in the patent application. The beauty of patents, especially in the provisional phase, that you want to describe your invention, not necessarily in terms of the real dimensions and size, but more about the functionality, right? What it does, and describe what each piece does from a structural standpoint, so that really it can take any scale and be used for perhaps even different industries, right? The same type of a spring, inboard spring fitting could be used for, mechanical automotive work, but scaled down small enough, maybe it could be used in the dental field, right? Inside of a tooth. And then on the huge scale, maybe used for mining operations. I don't know, right? So as long as you're describing a specific functionality, aspects of the structure, and each element of the invention, that's what's really going to be important, as opposed to actual dimensions. I mean, dimensions are one version, right? One actual, physical embodiment of your invention. there's probably millions, right? Maybe an infinite number of physical versions of your invention. You'll want to get to, of course, one, market-ready product fairly soon, I would imagine. But that's all part of design, product design, marketing design for when you're getting ready to sell your product. And like I said, the patents rights you own will hopefully be much broader than just that one version that you're going to market with first. Okay. Awesome. Well, my mouth is a little bit dry. I apologize for the my sound here. I'll stop sharing, and I'll wait at least another minute or so to see if there's any other questions that come in. I did see some people hop on. Looks like we have 8 people viewing, which is great. So thank you for those that are on. Give us a like or share the page with someone if you think they may be interested. I always say this, but it's kind of funny. If you got like a brother or sister or uncle, aunt, grandpa, right, then that is an inventor, right? And you know who they are. Do them a favor. Send them this link. Let them know that I'm on every Friday, 9 a.m. Pacific and noon on the East Coast. I'm trying to help people out, just get people started. And so, again, I'm offering this book you see behind me, Bold Ideas, The Inventor's Guide to Patents. This is available for free. That link I just posted above. You do have to give us just your name and email. We will send you a weekly email. Okay, you can unsubscribe if you want to, but it's great info. It's the blog articles that I write. So sign up for that. I'll give you a free PDF download to get started. And if you're ready, hop on the call with one of our advisors, and we'll get you started. Alan, you're awesome. Thank you. You're very welcome. All right, you guys. Well, I'm going to say goodbye. We'll wrap up in just a minute unless there's any other questions. We'll see you next week. It's been really cool having you, having all the viewers on. Flavio, awesome. You're good. You're always good with questions, man. Here we go. Okay, so if you put on a provisional utility patent and it gets granted, do you need to reapply for the original utility patent? Well, okay, here's a cool topic. Provisionals do not get examined. Okay, provisional patent applications don't get touched unless there is a race for that later. So what I mean is, so you file provisional, then a year later you file your non-provisional, and the examiners at the USPTO will then start looking at it once you file the non-provisional. All right, so there is a need to in essence, reapply. You've got to submit that non-provisional and make a reference. Say, hey, look, I filed this provisional way back when. You got to make that reference. And then the examiners will go take a look for it. And if there's another competing patent application that was also filed, right, in the sort of parallel universe, someone else filed the same invention, then the examiners will open up your provision to see who filed first, because that's what it's all about. All right. Well, thank you guys so much for this time. It's great to talk to you all. Have a good rest of your day, okay? Bye-bye. Go big, go bold.